In court, oral arguments aren't about reading a script, they're about persuasion. And the best advocates follow a structure that's clear, strategic, and flexible. First, the introduction. Set the tone. Start with your name, the party you represent, and summarize your position in one crisp line. May it please the court, I appear for the petitioner. The core issue is the arbitrary cancellation of a license without notice, violating Article 14. Next, the roadmap. Help the judge follow your structure. Say, I'll address 3 points: facts, legal framework, and the relief we seek. Then the facts. Brief and only what truly matters. Don't rehash your pleadings. Highlight what affects the outcome. Now, your legal position. Lead with your strongest point. Cite binding precedents first, persuasive ones second. Be ready to distinguish adverse cases without getting defensive. Move to application. Connect the law to your facts. This is where you turn theory into persuasion. Keep your language plain. Clarity is power. Now, the relief. Be specific. Whether it's interim, final, or a particular direction, spell it out. And above all, be responsive. Listen to the bench. If they interrupt, pivot. Don't bulldoze. Practice makes perfect. Say it aloud. Record yourself. Oral clarity isn't the same as written clarity. Because in the courtroom, structure wins arguments, before substance ever gets the chance.